And the next speaker is Senator Boyce.
Thank you, Mr. President, and good afternoon to my fellow senators. Mr. President, as you are aware, the batting after lunch is always advised to be slow to get off the mark.
Yes.
So I intend to start with a few singles and maybe work my way up to a 4 or 2. But for the most part, sir, I rise to perhaps lend a somewhat esoteric approach to the discussions that we have had so far. Indeed, the legislation is one where we understand the need of the government to bring the country in line with international standards as it relates to data protection. A quick Google search will show similarities of the legislation currently before us to that of the EU CDPR, as well as the UK Data Protection Act. And as usual, Barbados seeks to punch above its weight by incorporating the best of the best in terms of the highest standards and the most recognized attributes to be implemented locally. And that certainly should be applauded, while being cognizant that in our eagerness to do what we perceive to be of the highest standard, that we recognize we have to also provide the necessary framework, besides the legislative, which we're dealing with today, sir, but also the resources. I think the slang is the correct ability to load out or relevant runway to get this type of project out into the public. And the reason for this concern, sir, stems from the relevant definitions and principles contained within the legislation. I won't attempt to bore this house, but a quick glance at some of these sections, and if we start with section 4, we see the principles relating to the processing of personal data. And at section 4, from A to F, there are a series of stipulations that are quite intensive, sir. A matter of fact, this legislation, I have to admit, gave me some difficulty in its absorption, but it was done eventually. And it is quite detailed, and as set out, the penalties are onerous. So while there is the need to commend for bringing it in place, there's also the need for warning to ensure that before it's implemented, that certain steps are taken. So if we go briefly to section 4, sir, and we see that data, and I wouldn't read the entire clause set out, but you'll see, sir, clause 4.1 says data shall be processed lawfully. 4.1a. 4.1b says collected for specified explicit and legitimate purposes and not further processed. Clause 4.1c, the data collected shall be adequate, relevant, and limited to what is necessary, sir. Clause 4.1d, accurate and where necessary, kept up to date, and every reasonable step shall be taken to ensure that personal data that is inaccurate, having regard to the purposes for which it was processed, is erased. Step 4.1e, sir, kept in a form which permits identification of data subjects for no longer than is necessary. Clause 4.1f, processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage using appropriate technical or organizational measures. Well, that's quite a mouthful. And certainly we should aim to have these goals implemented. However, what that means, sir, is that an obligation is now being placed on the persons who conduct this exercise to have the necessary training and the necessary resources in place to ensure that they're equipped to do so. This, of course, when contrasted with the penalty for the failure to do so, would warrant some consideration. Now, it is understandable, and again, let me be on record as stating, this is legislation which the government has to put in place to protect data. But while you're doing this aspect of the legislation, in light of the strictness and in light of the potential penalties, certainly it would behoove the government to ensure that there are adequate resources to allow the relevant stakeholders to get themselves up to speed. Another example, sir, is now there is a requirement and protection in relation to the rights of children online. And that's somewhat serious, and it's the first time, besides the Computer Misuse Act, where we're seeing a specific reference to the processing of a child's personal data. We all recognize that we're online in one way or the other, and you know, the concept that you're online either only by your phone or by your tablet or by your laptop, that's archaic. You're online by your smartwatch. You might even be online by your car. Data is being collected by persons and being utilized and stored for a variety of reasons. So, sir, at Clause 8, there is reference to processing of a child's personal data, and that should be lawful only where and to the extent that consent is given or authorized by the parent or guardian of the child. What does that mean, sir, for a website operating out of Barbados, which allows children to access its contents? Necessary steps would have to be taken to augment the website's cookie policy and notification of end users before they utilize. And the issue, sir, of consent for processing children's personal data has proved to be somewhat difficult, sir. Actually, the United States was pretty much ahead of the curve on this one, because over 20 years ago, they had the Children's Online Privacy Protection Act. The EU has tried to bring it in place, and even in the EU, sir, and I'm reading and I'm referencing Taylor Francis online, sir, Information and Communication Technology Law article, volume 26, 2017, issue 2. This is what they had to say. In the EU, the General Data Protection Regulation, which is very similar to what we're discussing today, sir, has a section which deals with children's rights, similar to our Clause 8. And they say that in the EU, this assigns a prominent role to parental consent in order to protect the personal data of minors online. And for the first time, it requires parental consent before information society providers, and that is defined in our act as the data providers, can process the personal data of children under 16 years of age. This provision is new for Europe, and even in Europe, faces many interpretation and implementation challenges. So what about us here in Barbados, sir, without any of the resources that they have? What do we do? So we need to be aware that while the goals are lofty and the aim certainly should be commended, when we start to get into the legislation, especially with the penalties that could arise, we need to be making sure that we tread appropriately in the circumstances, sir. So education will certainly be key as to how this act is going to be implemented. And I believe I've heard from the government that there is going to be discussion on that before the end of the day, sir. Now, it is pleasing to see within the draft, sir, Clause 17, which seeks to prevent processing of data for direct marketing. All of us know when we go to a website and attempt to browse Amazon and pay our 2% tax on our VAT, because we are very glad to play our part to support, that your purchases are being tracked. So if I seek to buy a golf club for a recent retired member of the other place, all of a sudden I'm receiving information about improving my golf swing and what book would assist in that process. Now that is certainly allowed, but there are certain restrictions, and they call that implemented within the cookie policies. And we all know that we ignore those cookie policies. That's when you go to a web page, and as you turn on the web page, Mr. President, you see a lot of legal jargon go out. Lawyers get a lot of money to draft these clauses, sir. So this is a good bill. And lawyers get a lot of money to draft these clauses, which set out what happens when you go to this web page and what is going to happen to your data that you enter, willingly or unwillingly. But the point is, sir, is that we are creating a specific legal tool which seeks to prevent the utilization of direct marketing under this legislation, and that should be commended. Now, sir, if you turn to clauses 23 through to 25, this is where we start to get a little into the specifics, sir, as to the obligations under the Act. And these are the obligations which the persons who are involved in the data acquisition now have to find themselves able to stay on top of. So, sir, you'll see at clause 23, there's a section called adequate level of protection. You're now required for this adequate level of protection to have protection which is adequate when you have regard to the nature of the data, the country or territory of origin, the country or territory of the final destination, the purposes for which is gathered, the law enforced of the territory in question, the international obligations of the country or territory, any relevant codes of conduct, any security measures taken in respect of that data. Sir, then we go to appropriate safeguards. Appropriate safeguards, sir, starts off with the concept of a legally binding and enforceable instrument between public authorities, binding corporate rules, standard data protection clauses, sir, contractual clauses authorized by the commissioner between the data controller or data processor, sir, provisions authorized by the commissioner to be inserted into the administration arrangements. And sir, we have not yet identified the data commissioner or the resources to support the same. So we have a situation, sir, where you are seeing that the requirements of the legislation requires an increasing amount of corporate sophistication just to implement. And if you do not implement, sir, or you do not follow these rules, you find yourself in breach. And the penalty, sir, is set out at clause 27, sir. And clause 27 says a person who contravenes section 22, 23, or 24 is guilty of an offense and is liable on summary conviction to a fine of $500,000 or to imprisonment for 3 years or both. So as I said, this is a great bill for the legal fraternity. But the problem with the legislation at this stage without, and I'm assuming that we're going to hear that there is a solution, and the government has been proactive in that regard, is that if you are imposing these penalties in light of these requirements, which are so onerous, we need to make sure that persons are given the appropriate lead time to put their house in order, sir. And that's going to be a theme which I repeat, sir, during the course of this somewhat short presentation. Sir, at clause 62, there is reference to the security of the processing of the data. So this is another obligation which is put on the persons who will be responsible for this activity. Sir, if I was an IT professional now, I'll either be very happy or very sad, depending on the resources I have within my organization. And sir, listen to the requirement for the security of processing at clause 62. Taking into account the state of the art the cost of implementation, and the nature, scope, context, and purposes of processing, as well as the risk of varying likelihood and severity for the rights and freedoms of individuals, the data controller and the data processor shall implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk. Now, Mr. President, you would have had a field day with that clause, sir. Because the concept is, I believe, that you take the necessary security which is determined based on the data that you have and the potential risk that you observe. But when you see that type of language, you get excited or you get cautious. Either which way, sir, the requirements are potentially quite strict. And we go on, sir. If there is a breach of this security that you're supposed to have in place, the data controller shall, without undue delay, and where feasible, not less than 72 hours, having become aware of, notify the personal data breach to the commissioner, unless the personal data breach is unlikely to result in a risk to the rights and freedoms of an individual. So let's unpack this a bit, sir. After you have the requirement to put the necessary security in place, if you have a problem or if you discover that there's a breach which you should be reasonable about and be up to date about, you have 72 hours within which to get this information to the commissioner. And we hope that you have the necessary resources to do so, because if you do not do that, we're going to speak to the penalties shortly. And then finally, sir, not only do you have to report to the commissioner, you have to report to the individual who is affected by the breach within 72 hours. So the intent of the legislation is good, but we need to make sure that when we are putting these burdens or these obligations in, and this is interesting because it works for and against the ease of doing business. We need to be able to protect the data because that brings us within the international standard that is acceptable and is warranted for the persons who will be seeking to invest in Barbados. However, are our local entities in a position to adopt this legislation and move forward? Sir, when you look at it in the context, again, with the potential penalties, sir, let's go to section 83. So what is the penalty for not notifying and not doing what you're supposed to do, sir? And I think one of my fellow senators was very glad with the amount of fees. Well, it will help the government coffers, but let's make sure that we're being fair in the application, sir. You're facing the risk, as repeated above, in terms of, and I don't want to misspeak, sir, but the breach of the section will set out what the penalty is in terms of enforcement. And sir, we go on and on and on, where you find that there are these penalties. I think it's, I'm not finding the exact section, sir, but it's between 50,000, sir, or, well, I will have Senator, I'm sure Senator McConney will clarify. But in any event, sir, the potential breach for the section is not small, and you may find yourself in seeking to provide the level of protection, punish at a quite uneven scale persons who should not fall onto that mantle. Now, sir, we could go on and go on and go on, but it seems to be this continued system of implementation, requirement to have sophisticated networks, and heavy penalties if you do not comply with it, sir. When we look at clause 83 of the bill, sir, failure to comply with the notice. Now, this is when the commissioner is monitoring and doing the activities, and you receive a notice saying that this is an enforcement notice in relation to your data. If you fail to comply with the notice, Mr. President, that's a 15,000 fine or a term of imprisonment of 6 months. And if you are a person who, in purported compliance with the information notice, makes a false statement or recklessly makes a statement which is false in a material respect, and sir, you would know what a reckless statement could be in these circumstances, you're faced with a fine of $500,000 or a term for imprisonment of 3 years or both. So it is quite onerous, sir. Finally, sir, we have lovely section 9093, which I think we could all agree with, which speaks to unlawfully obtaining of personal data and carries the necessary penalty of $10,000 and a term of imprisonment of 6 months. Now, how this will relate with the existing Computer Misuse Act, I think certainly is something that will be exciting, but I think this also has a lot of connotations for the personal sphere and to some extent social media. At section 93.4, selling data. I think we can all agree with this. Clause 93.4 carries $100,000 fine and 3 years. And I don't think anyone, sir, can object to this because this is an example of a direct offense. But if you have a direct offense where someone is selling data deliberately with the necessary actus and mens rea and goes out there and does that, you certainly say 100K, we can understand the need in terms of preventing or stopping such activities. But then when we compare and contrast $500,000 for breach of something which we understand the intention, but which could be attributed to a variety of factors, even ineptitude, it may seem as though the scales are somewhat tipped away from the delicate balance that Lady Justice seeks to impose. Sir, this legislation certainly will be supported from my part, and it is understood what the government is trying to do. However, my humble urging is that it's rolled out with the necessary warning and training to allow the necessary stakeholders to put the appropriate safeguards and resources in place, and that the education campaign to support it is widespread. And that, Mr. President, concludes my presentation on this topic. Thank you, sir.
Thank you very much, sir. Senator McConney.
Mr. President, the debate that we have had so far on this data protection bill has been wide and it has been useful. And I believe that from what we have heard today, sir, that we can admit that there is some need for further public education as well as the opportunity to ventilate this bill further. And I therefore beg to move that we refer this bill to a joint select committee of both houses with possible the nomination from this house of Senator Boyce, Senator Drakes, Senator Adams, Senator Sands, and Senator McConney as part of that team.
The question is that the bill under consideration be referred to a joint select committee of both chambers, and that sitting on the committee for the Senate will be Senators Boyce, Drakes, Adams, McConney, and Sands. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it. And this bill under consideration will now be referred to the Joint Select Committee, constituted from the members of the Senate earlier indicated. What's happening next?
Mr. President, we committal introduction of bills.
Mr. President, I beg to give notice of the resolution to seek the concurrence of the Honourable the Senate in the amendments made by the Honourable the House of Assembly to the Public Service Retrenched Workers Bill 2019.
Mr. President, revert to public business. Order number 10, in the name of the Honorable Leader of the Senate, to move the passing of a resolution to seek the concurrence of the Honorable the Senate in the amendments made by the Honorable the House of Assembly to the Public Service Retrenched Workers Bill 2019.
Mr. President, you will recall that at the last sitting of this Honourable House, a recommendation of amendments were sent to the other place. And this morning, I make reference to the communication this morning from the other place, which would suggest that there was no concurrence with the amendments of the Honourable the Senate. This government is seeking, Mr. President, to pay the gratuity and pensions for 84 workers who were separated from government during the retrenchment process. And the Honourable and this government believes that the amendments that were made were not in keeping with the decision of the Cabinet as originally represented, and that the amendment would have been in conflict. I now beg to move that this House concur with the amendments of the Honourable the House of Assembly in the matter of the Public Service Retrenched Workers Bill 2019.
Sir, thank you very much. I have read this bill again and I'm a bit conflicted. By profession, I am a trade unionist, and I always like to know when workers get money. You know, that means I'm happy when workers get something, you know. And this bill intends to give some money to people who were retrenched from the public service in circumstances where they shouldn't have been. That said, sir, the conflict that I have is that this piece of legislation that we sent back contains 242 words, and they're arguing against themselves. They don't make a lot of sense, but as I said, I will not oppose this. The people getting money, but I cannot vote for something as badly drafted as this. So I will allow it to pass without making any noise. You know, but it is very poor. I'll give you an example, sir. It says at clause 2, the Accountant General is hereby authorized and required to make payment of gratuity and pension out of the consolidated fund in respect of the public service of 84 public officers who were employed in the Ministry of Transport, Works and Maintenance, and who were retrenched on the 19th of October, 2018. Clause 2 goes on to say, the reduced pension due to persons referred in subsection 1 shall be payable upon their attaining the age of 60 years in accordance with the Pension Act. Sir, clause 1 does not refer to any reduced pension. You see, but they're saying the reduced pension referred in clause 1, but clause 1 doesn't say anything about reduced pension. You see why I said I want people to get the money, but I can't be associated with something as poor as this? That is one aspect of it. The other aspect I spoke of before, when Bill was before us the last time, is that in clause 2 they're saying you will get the money at 60. But clause 4 is saying the money that we give you now is full, shall be the full satisfaction of the liability of the Crown for the payment of retirement allowances and benefits under the Pensions Act, Cap 25. So you're saying, I am going to give you some money now, and I have nothing more for you in clause 4, but clause 2 is saying, I am going to give you something at 60. So it does not make sense. But I want them to get some money now because some of them are 30, 32, 35. You know? So I can't, so I'm not going to stop them from, I don't want to stop them from getting any money. But sir, I cannot allow myself to be associated with something as bad as this. Thank you, sir.
The question is that there is concurrence of the Senate to the amendments to the bill as determined by the Honourable.
You,
Senator Franklin's
K.
Mr. President, I just wish to say to all this honorable House that the concerns mentioned have been noted. We respect the position that has been put forward by our fellow senators in this House, and I wish to again move that this resolution now pass.
The question is that there is concurrence of the Senate to the amendments of the bill, Public Service Retrenched Workers Bill 2019, as determined by the Honourable House of Assembly. All honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it. A division has been called for.
I thought France said, you know,
He gives assurances which he don't honor. He gives assurances which he don't honor, man. Is the clerk ready to
Yes.
record the individual votes of members?
Yes, sir.
Please proceed.
Senator Moore. Senator Moore.
Aye. Aye.
Senator McConney.
Aye.
Senator Dr. Springer.
Aye.
Senator Cummins.
Aye.
Senator Haynes.
Aye.
Senator Sands. Senator Adams.
Aye.
Senator Franklin.
Abstain.
Senator Drakes.
Aye.
Senator Rogers.
Aye.
Senator Wiggins.
Aye.
Senator Boyce.
Aye.
Senator Moore.
Aye.
Senator Tate.
Abstain.
Senator Nurse. His Honor Senator Greenwich.
Aye.
Mr. President, the results of the division, 14 honorable senators voted in favor of the motion.
Give me that number again.
14
14 honorable members,
voted in favor of the motion. There were 2 abstentions.
2 abstentions.
2 abstentions. Therefore, the motion
The
is passed.
results of the division called for are as follows. 14 honorable members voted in favor. 1 honorable member voted against, and there were 2 abstentions.
No. There was no one voted against.
Oh, sorry,
one
sorry.
voted
President,
Two-
against.
There were 2 abstentions.
Two abstentions. 2 abstentions, nobody voted against.
I'm sorry, yes. 14 members, honorable members voted in favor, and there were 2 abstentions. Thank you. What's the next issue?
Order number 3, sir. In the name of the Honorable Acting Leader of the Senate, to move the passing of a resolution to approve under Section 5 of the Crown Lands Vesting and Disposal Act, Chapter 225, the lease to the Maria Holder Memorial Trust of the parcel of land, the property of the Crown, situate at Government Hill in the parish of St. Michael on this island, for the purpose of the construction of a nursery school.
Mr. President, the resolution seeking to lease the parcel of land at Government Hill, St. Michael, to the Maria Holder Memorial Trust for the construction of a nursery. It follows Cabinet decision made on April 4th, 2019, which agreed that the lease of 5,957.1 square meters of Crown land at Grandview, Government Hill, be leased, and that the rent shall be one-time payment of $200 plus VAT payable in advance, that the premises are being leased for the purpose of construction of a nursery school, that the land, together with all improvements, shall be leased back to the Crown, that the lessee shall be responsible for the costs of development of the site, and that the lessee shall comply with the requirements of all planning, building, safety, and health and related legislation throughout the term. And further, that the lessee shall indemnify the Crown from all actions arising from its use of the premises. I beg to move that this resolution now pass.
I second that. You want me to say something? What do you want me to do? Huh?
Oh, yeah, you nursery. You want to speak? Come on, let me read a second. The resolution? I beg to move, the resolution? I moved. That's what I did. So that's the question?
Mr. Clark? 1 minute, please.
Resolution do not pass. Move, you move it, the resolution do not pass.
I think that's the question is. The question is, has the resolution do not pass?
You go put it to the Senate, the question is that the resolution do not pass.
Which notice was just given?
Yeah, this one.
She would have put the motion on the anniversary. Let's put the question.
So this one here,
Yeah, but
resolution
I-
for this Crown lands vesting at Government Hill, that for purpose of the construction of the school, that do not pass. Okay, who's the next one?
Order number 4, sir. In the name of the acting leader of the Senate, to move the passing of a resolution to approve under Section 5 of the Crown Lands Vesting and Disposal Act, Chapter 225, the lease to the Maria Holder Memorial Trust of a parcel of land, the property of the Crown, situate at Upton in the parish of Christchurch in this island, for the purpose of constructing a skate park for public use.
Mr. President, the resolution before this House to lease this parcel of land measuring 9,111 square meters at Upton Christchurch for the purpose of a skate park by the Maria Holder Memorial Trust is much welcomed by this government. It is a purpose-built recreation facility which will be used for sports such as skateboarding, BMX riding, and even in some cases, wheelchair racing, where there would also be opportunity not just for persons who are differently able to be able to participate in sporting activity. The Maria Holder Memorial Trust is a charity that is registered under the Barbados Charities Act, and it has a mission that involves the alleviation of poverty to improve the quality of life of vulnerable people, particularly in Barbados. And so doing its projects focus on education, training, culture, the arts, emergency and disaster relief, healthcare, and sports. Now, some of the terms of this lease is for the term of 20 years with an option to renew for a further 20 years. The rent shall be a one-time payment of $200 plus VAT payable in advance. The rent shall be subject to review at the end of the first term. The premises are being leased for the purposes of a skate park only, and the lease shall indemnify the Crown for all actions arising from its use. I beg to move, Mr. President, that this resolution now pass.
The question is that a resolution approving the lease to the Maria Holder Memorial Trust of a parcel of land, the property of the Crown, situated at Upton in the parish of Christchurch, for the purpose of constructing a skate park for public use, do now pass. All honourable members in favour, please say aye. Aye. Those against, please say no. We think the ayes have it. Yeah. Suspension for 20 minutes.
Mr. President, I beg to move that this honorable house now be suspended for a period of 15 minutes, 20 minutes for consideration of a matter for the city.
Question is that the honourable Senate be now suspended for 20 minutes. All honourable members in favour, please say aye.
Aye.
Those against, please say no. We think the ayes have it. We are now in the suspension for 20 minutes.
Good. You're on.
Our period of suspension is now at an end, and we are now back in session. The Senate is now back in session.
He said the Senate resumed. He said that. Right?
He goes.
Hmm?
He didn't say anything.
He didn't say anything. He said something about resumption.
He didn't say anything.
You don't got anything?
But he had took one.
Mr. Clark, I have it.
Order number 9, sir.
He's scared.
In the name of the Honourable Acting Leader of the Senate, to move the passing of a resolution to approve under Section 5 of the Crown Lands Vesting and Disposal Act, Chapter 225. The vesting in the Barbados Tourism Investment Incorporated of parcels of land, the property of the Crown, situate at Bay Street in the parish of St. Michael on this island for the public purpose of tourism development.
Mr. President, with regards to the aforementioned parcel of land at Bay Street to be vested in the Barbados Tourism Investment Incorporated, this will provide the opportunity for Barbados to develop its tourism product, for there to be economic enfranchisement of some young of entrepreneurs in Barbados who can participate in the growth opportunities of this tourism development for Barbados. And it is with these few words that I beg to move that this resolution now pass.
The question is that the resolution to approve under Section 5 of the Crown Lands Vesting and Disposal Act, Chapter 225, to approve the vesting in the Barbados Tourism Investment, Inc. of parcels of land, the property of the Crown, situated in Bay Street in the parish of St. Michael in this island, for the purpose of tourism development. Do now pass. All honourable members in favour, please say aye.
Aye.
Those against, please say no. Methink the ayes have it. The Barbados Water Authority validation.
Not that, no, but you got to do
We committed, sir, of announcements by Your Honor, President.
We are revisiting announcements so as to give me the opportunity to read the message from the Honourable the Senate to the Honourable the House of Assembly. And the message reads as follows. The Honourable the Senate has the honour to inform the Honourable the House of Assembly that on the 31st day of May 2019, the Honourable the Senate committed the following bill, Data Protection Bill 2019, to a joint select committee of the two houses, comprising 6 members of the Honourable the Senate and 5 members of the Honourable the House of Assembly, and has approved the following terms of reference for the committee. 1, to inquire into and determine whether the bill as drafted effectively fulfills the express objects of improving the protection of personal data. 2, to examine whether the bill as drafted will, upon effective implementation, contribute to an ethos of compliance with data protection, thereby promoting transparency and accountability. 3, to make recommended changes, if deemed necessary, to the bill as drafted for further consideration by the Chief Parliamentary Council. And the Honourable the Senate has appointed the following senators to the Joint Select Committee. Senator the Honourable Ms. K. S. McConney, Minister of Innovation, Science and Smart Technology. Senator Damien R. Sands. Senator Rawdon J. H. Adams. Senator Ms. Crystal Hendricks, Senator Kevin Boyce, Senator Ms. Althea Wiggins. The Honourable the Senate has the honour to invite the Honourable the House of Assembly to appoint 5 members to the Joint Select Committee. And that is the message.
Revert to public business.
Mr. President, just wish to bring to the attention of this honorable House that at the time when the representatives of Senate of the Joint Select Committee was announced earlier, there were 5 members. You will notice now that in the notice that you just read, we have now increased that number by 1 in compliance with the standing orders of this honorable House.
Thank you. That just brings us to the end of public business. You may so announce.
Mr. President, I now beg to move that we adjourn without a day appointed. Seen a day.
The question is that the Senate be now adjourned without a day appointed. Honourable members in favour, please say aye. Aye. Those against, please say no. And we now stand adjourned without a day appointed.